So, hello and welcome to our CFWebinar UPC Litigation Pressing Issues. This webinar will be recorded and you will receive links to the recording as well to our slides, which we will show in the next about 60 minutes within a week or something like that. We will distribute them to all attendees and everybody who has applied. Yes, if you have questions, we would like to ask you to use the questions and answers tool of Zoom. You'll find it on your screen, and we will try to answer your questions. So we will start with, as I mentioned, with a presentation which will last about 60 minutes. And then we have about 30 minutes of remaining time to discuss, to answer questions, and yeah, to do some follow-up. Yeah, my name is Gottfried Schüll, and this is my colleague Matthias Karlhuber. And Matthias, perhaps you introduce yourself first.
Thank you very much, Gottfried. So my name is Matthias Karlhuber. I'm a partner here with Carlson Florak. I'm with the firm for more than 20 years now. So from the outset, I'm a mechanical engineer, but most of the time I'm doing medical technology or information technology. So that's my main focus in terms of my work. And I'm mainly concerned with EPO opposition procedures. So that's my focus in my daily life.
Yeah, and to myself, I studied physics and I'm a partner as well, long-standing partner with Carlson Florak. I'm mostly involved in cases about information and telecommunication technology. I do almost only patent litigation. So I'm a key accountant in many patent litigation cases over the last 20 years, more than 20 years now. And yeah, and we both will bring our input especially from our perspectives to what is going on with the introduction of the UPC, what we expect. Everything we will tell you in this webinar is, or most of it, is not a natural science. It's some speculation. But we want to give you our opinion on the present situation. The UPC is coming. That's our clear expectation. It's coming soon. The UP is coming, and there are many things which we in the IP community, where we work for 20 years or more, have to rethink. And we believe it's the right time to do that. We waited a long time for the introduction of the UP and UPC, and now it's on its verge.
It's always been there.
Yeah, yes.
When I started in the profession, it's always been, oh, it's going to come. So
right.
Now it's there.
Right,
finally.
Right. Exactly. Yeah. So we waited a long time, and partially Germany was responsible for that due to the constitutional appeals. But now the road is on the rails. Yeah, say it like that. So I start now the presentation. I hope you see it. Yes, and we immediately go to the. We already can skip that. We told you. So the first thing is we want to talk about is the filing options. That's more or less background. So we do some to fill up to make a bit up the background to have a better basis for our following up discussion, that we don't miss anything. And at the end, we want to give you the action items, depend on which size of company or type of company you are. So what we discuss is represented by these action items here in the right above corner. Here we talk about the filing strategy of applications. As you all know, we have the effective date of the UPC. As we said, it's coming. And yeah, we know that we have to adopt our filing strategies in the prosecution. We have to make our crosses at other places. Yeah, well thought. Yeah, it's a simple manual or IT action, but you have to think about that well.
Yeah.
And the main considerations are, first of all, you have to be ready. That's always an issue here in our presentation. You have to be ready on the effective date of the UPC. So there is some time, so it's not a totally pressing issue.
Yeah, but it's going to be close. I mean, all of you know Germany is going to be the last one to actually deposit the instrument of ratification. And as soon as Germany does that, it's the first day of the 4th month after the deposit of the instrument of ratification. So Germany is expected to do that only if all the preparation work is done, which is going to be, well, it's starting now. That is the thing that started with the ratification of Slovenia of the protocol of provisional application. So now Germany is going to look at it and say, okay, at some point, yeah, it's good enough. So preparation is done. And then they deposit this instrument of ratification, which then triggers the 4 months. And after those, on the first day of the 4th month, after this deposit, then this is the effective date of the UPC. So we don't know it precisely, but it's expected to happen sometime later this year or even early 2023.
Yeah, so exactly. That's the point where you have to be ready, and before you are will get ready, we have to think. Oh, we believe the main considerations are, first of all, of course, validation costs. You have to think about designation fees and translation costs. What the EPO has calculated is that when you go for more than 4 or 5 countries, the UP will become more cost effective, especially also when you think about the annuities. So the annuities accumulate for long-lasting patents. There's a serious difference.
Yeah.
I saw a calculation where there's a difference over a 20-year patent, of course, compared to the full-blown validation, which you compare, of about more than 100,000 euros. So that's really a difference.
Which is the extreme scenario, though. Right, nevertheless. Right. So, but you know better what is your average rate or average number of validations you do. That's the rule of thumb. It's about above 4. Then you might be better off or cheaper off with the UPC, the unitary patent, not the UPC. But yeah, you see, there's the third point that we have on that slide, which is the abandonment. The abandonment scenario is you can't selectively abandon, which is the major downside of that. You're stuck with it. You can't selectively abandon, can't say, oh, I don't need France anymore, I don't need Germany anymore, so I just keep 1 or 2 of the core countries that I would want to have, but that's not possible, of course. So that is something to factor in as well. So which may save you a lot of money in annuities later on for long-running patents, where you just you do that pruning process where you say, okay, I just keep this one. That's the only one I need.
My personal view, and I have to admit, I'm not active in prosecution anymore. But for me, it feels a little bit like the UP will become a standard selection as the US patent, as the Chinese patent are. Of course, you might not be interested so much in patent protection in Alaska, for example. There might be European countries, I will not give any, which might be similar attractive than Alaska. And perhaps the end will be, it's also the simplicity is certain. It has to be considered. You cannot make mistakes. You have to not to take care of all annuities. It's simple. So I believe at the end that will also be a major consideration, and we will see what you as the applicants, as the users of the system, will do. So it's interesting.
Yeah.
That's as I said, that's a little bit background. We go to the next point, and
that's the €1,000,000 question. Stay in or opt out. What are you doing with it? At the end of the day, I mean, many of you will have certainly already asked yourself that question. We've put it here on the screen, so we know that there is this. We've already talked about the effective date of the UPC and 3 months. The 3 months before the effective date of the UPC, as you know, depending on Germany's deposit of the instrument of ratification, you're going to have this sunrise period. So you're probably very familiar with that. So within which you can opt out, preemptively already opt out before the UPC comes into force. You can, of course, during the so-called transitional period, we have it down there on the slide, the 7 years currently, which may be extended by 14 years at any time, any existing European patent or European patent application after the sunrise period. So you can do that. Every one of you knows that, certainly. So the question is, when and should I do it? Should I actually do it? Of course, we've already briefly touched upon it. It's consideration is geographical scope of protection. The beauty of not opting out, and I'm talking about the existing European patents and patent applications, especially the European patents that are the classic, bundle patent that you still have in your as an option. You can always just validate as you are used to do it. But the beauty of not opting out is that you can hit the entire scope of countries that you've covered with your validations in one litigation. So before you go to one venue and cover that entire geographic scope that you have. That's the beauty of it. Catch all in one sweep. But you go to the next bullet point. You also there is always a downside. As in most cases, there's always a bit of a downside to it. You risk a central invalidation attack. That's your risk. Every one of you is certainly aware of that. That this thing gets killed in one sweep, just with a central attack. That's always there post grant with the EPO opposition. So you for a certain amount of time, the 9 months after post publication of grant, you always have that central risk for an EP patent. But nevertheless, you perpetuate that essentially by opting. Not opting in, by not opting out. That's it. So you have to actively opt out. So that's the question. That's something you have to balance against it, and that's certainly a question you're going to ask yourself. Do I really need this central attack together with that I can run on the basis of a patent? With the trade-off of the central attack against my patent, the central invalidation process, that may be and that is certainly very diverse for whoever your company strategy, your patent strategy, will have a major impact on it. You may be, for example, a very seasoned company which does, and seasoned, I mean in terms of litigation, and you may have a scenario where it's not so much a product line that is the same across entire Europe,
as we have in SCPs.
As you have it in SCPs, in many cases where there is, well, it's pretty much the same.
It is the same.
It is all over the. It has to be the same all over the place. Yeah. But that may be totally different for other products, for other businesses. So this should be the main driver to your decision. Is it really worth, or am I sophisticated enough and interested in really using purely national law? There may be good reasons for that, because you're going after certain defendants which are totally different, which are in a specific country, in just one country, have a country-specific product or service that they are offering. So that may really factor in. Do you really have to do that, or are you really benefiting from this central attack and central risk compared to what you can achieve with individual litigation in those countries? Yeah.
And we heard from clients that they tend to, or some clients tend to follow the road they followed for the last years, or even more, to use the national proceedings to go after individual infringements in, for example, non-SCP cases, where enough of so not only doing SCP cases. And but what we believe, which is also an aspect to consider there, is if you won at one venue, you have something like, I would call it a model case. We call it a model case you have one venue, one direction. For example, if you won in Germany against a German target, a German defendant, and then you before the UPC, and you then go after, let's say, a French target again at a German venue, then you have the same court, at least with respect to validity, mainly discussing the same issues.
Yeah.
And even with respect to infringement, you might have different infringements, but similar infringements. So
Yeah.
The way is somehow a little bit paved for that to go against another target in another country, which is totally unusual so far.
Yeah.
So and that might be something to consider.
Yeah, that's the motivation of the next target is certainly going to be higher to to not get into the fight when you've already won the first model case. They will know, okay, if you're using the UPC, then the decision is not going to be on infringement, is not going to be a different, especially for an SEP.
For SEP,
there is no other way of deciding it. So you basically, that's the benefit of it. You do it once, and targets in different countries also covered by your European patent, the non-opted out patent. There's not much for them to do. You've most likely gone through invalidation already before in the first instance, in the first proceedings. So there is not much to do for them. So that's something that is really for that particular scenario where you really inevitably have the same infringement situation throughout all the countries. You're gonna end up with that scenario, and it's really worth considering.
Yeah, especially I believe also, of course, I'm coming from the SEP side, as mentioned all the time, but also in other cases, I can't imagine that you want to take the opportunity of a case which is at least similar to the previous case before the same court. That's a different situation. Oh, I just got a notice my device will switch off. I have only 50 seconds. 50 seconds, and I cannot select here. I believe that's the screen which is complaining about switching off. Sorry for that interruption. We try to solve that. We have another 35 seconds. So but coming to the next point, we believe that the UPC will be interesting for many, and accordingly, we think about the question of training as a consideration. And we will come.
We'll get to that. We will get to that later on. We have a specific point on that.
Yeah.
So at the end of the day, but you may also, just to round that off, you may have a similar scenario as we have, for example, or have had. We still have it. Think of the car industry, the automotive industry, especially cars. You're not gonna manufacture cars differently in France or in Germany. So at least for the really basic parts of the car. So this is also something. So winning a case in Germany, for example, is good enough. It's good enough to cover pretty much everything in Europe. So this is also something that you have to consider. What's my business, of course? What are my business goals? What is my strategy? And that also, well, transcends into your patent strategy.
Yeah. And then we may come exactly to the next point here, which is the question. We published a blog Beitrag, blog entry recently, and about that issue of simultaneous protection, which has been introduced into German law. And this has been discussed a lot and reflected. And I believe that's an important point here to consider in that connection, because directly, even if you do not think it from the beginning, relates to the introduction of the UPC and the UP. So the German government has introduced an amendment to German law which allows for simultaneous protection of a national DE patent in parallel with a unitary patent. And the intention of that regulation is indeed to enable competition in between the UPC and the German infringement courts. This is really, you can have both of two, you can have both worlds. You can have a national DE patent and a UP granted, and then can make a decision, do I want to use the UPC or do I want to use the DE before national court? And that, I believe, is an important consideration for everybody who is considering patent infringement, because it gives you, as I said, the best of two worlds.
It's a further tool that you can use, and it's
easy.
It's fairly easy.
The costs are pretty low. So for a national German application, it's about the official fees are 100 euros. You can file machine translations, so the translation costs remain also low. And as you know, there are other countries which have that too. You can defer examination by 7 years. So we will, at least for 7 years, we will not have an examination procedure.
If you wish, you can have it sit there.
Yeah, exactly.
Just as a backup. Essentially, okay, you will have to pay the annuities, the maintenance fees, but still. Well, it's up to you.
Fees for the first,
it's considerable depending on how large your portfolio is, but still, it's at least something to consider, just to keep it as a backup, to know, okay, if something goes wrong, for example, on the UP track, you still have it, and you still have it in a venue, which is, well, we all know one of the most heavily used in patent litigation.
That's right. And we believe that's an important and interesting option, and you should have in mind, and we believe that's one of the most pressing options, because the time limits to file for the national patent expire every day for whatever application you're running.
Depending on how you process
you have to file for DE patent at a certain point in time, and later on it's no longer possible. I believe that's something which should be urgently considered. How to proceed with that option. And something structural about our presentation. We on the top right side we have here this icon.
Our icons.
Our icons. This is the icon for simultaneous, or some call it double protection,
parallel protection.
Parallel protection. We will come to these icons later. Yeah. So that's a clear additional option, which is a little bit unusual. So you can, at least for Germany, I don't know if any other country has enabled a similar situation. You can have both worlds, UPC and national patent.
Of course, it's not for free, but it's depending on if it's your strategy, strategic decision. Is it worth it for your business? Again, that's in the long term. You might well consider that, and we know about clients who really are into that track, because they are, but it's more companies which are more seasoned in terms of litigation, who want to take advantage, of that additional national option for several reasons. So for them, it's that's certainly an option.
Especially in you mentioned that already, and we will come to that in more detail, as Germany is in patent infringement venue, which is really important with respect to patent protection worldwide. So that's so.
You want to ask the question?
You're right. Good that you told me. So I have to find them. Okay, question B.
Okay, so we wanted to ask you a question directly related to that. And you see, do you see it on the screen? You have to activate. You just have to
I have to start. Okay, start.
Okay, so there's a question, and we've got 4 answers for you. So I just quickly read it out. And I have to move a bit. So one option is to mitigate early stage risk of uncertainty with UPC litigation is to seek parallel protection via national patents. And the question to you is, do you use it? Do you intend to use it? Or are you saying, no, it's too expensive, and we would be very interested in to see what your options are. And now we see, there is.
We have the other options, yes, as a general approach, but only for certain transition, and as a general approach. And what we can see already, you cannot see it unless you will release it.
So, but you see, as the responses come in, yeah, it's the second reply only for a limited set of important patents. Of course, that is, well, you might think it's straightforward, but in some cases, but again, that depends on your business strategy. What's the best thing for you?
Yeah, but others all say, and also as a general approach, it is an option, and yeah, and I believe we can terminate the yeah, we've got Paul, and you see the results. So as we told, we have to release them. So now I release the results.
Okay, so you see, there's a clear, well, sort of a clear 55%, 54% of the responses are actually, yeah, we're going to use it to a limited amount, which is a sensible approach, certainly. There are also others, also for them, obviously, according to their business strategy, it is, but that's the majority is gonna have a, yeah, as I would say, which would be your first guess when you are into patent litigation,
right.
Particularly when you're particularly interested and want to keep that flexibility of using that national jurisdiction as well.
Yeah. Okay, thank you for this first for your first answers, and yeah, I believe it's
time to move on.
Yeah, exactly. It's your part.
That's my part again. So, yeah, we've already briefly touched upon it. Training the UPC. So what does that mean? At the end of the day, we all know we're going to end up with the UPC. The UPC actually coming to life, being there, and the question is, do we want to use it? If we don't use it, if everyone's opting out, what's going to be the impact on the court and on the decisions? In my view on that, my personal take on that is, I think we have to train the system. Look at the German system. The German system has developed over more than 100 years of jurisdiction of patent cases in that field. So, and it's been heavily used, and that's the reason why they are taking the courts are taking decisions. Bold decisions, I would say, at some point. They have confidence. There's a lot of case law. You know what you're ending up with at the end of the day, and at some point we need the UPC to be there as well in order to be an attractive venue. So we can't just neglect it. I think that's that's it.
Or we will go back to the national system. Yeah, you only use the DE because you don't want to use the UPC, and but that's no option, I believe. Everybody agrees, certainly not. That's the simultaneous protection is an option to have alternatives in the transition situation, and perhaps later on. But the only option, I believe, it's the UPC is offering too many additional tools.
Yeah, just use it, and keep in mind you've got the opportunity to shape it with the cases you feed into it. So there is a good reason for actually using it. Depending on to what extent you're going to use it, that's going to be interesting. What you do? Oh, sorry, went a bit too far. so that's but that's also a consideration. Is it going to be something that you want to sit back and say, oh yeah, let the others do the job. I'm not gonna feed anything into the process of my patents. I'm not going to expose them to that system. Or is it really worth, on a long-term perspective, to actually feed the system, train the system, make it work? Because at some point in time, after the transitional period has ended, there is no opting out anymore. There are still your old the patents that you've opted out for before the end of the transitional period. But at some point, it's going to come. It's going to come in 7 years or in 14 years with the extension. It's going to be there. So the only option, if you want to still want to use the European patent application route, you have to sort of be aware of that this is then the only court that is competent for those cases, unless you have you just follow exclusively the national route, which may be an option. But for most of us, and it absolutely makes sense to use the system, at least in the long term, and to get it up to speed to some extent. So
yeah, and you have the as we showed, we have the option to file for simultaneous protection. So even when you have a case running before the UPC, or perhaps have lost before the UPC, and then you can then you have trained it to some extent, yeah, and you can still use the DE patent. So there's no blocking effect, yeah, on that. So I believe there's a lot of incentive on the long term on training the UPC. It is some burden for the time being, but you have to also consider that it's not only about, we're not discussing about the UPC is not a machine, it's people.
Yeah.
So we have to get people to be interested in going there,
yeah,
to be motivated to use their expertise. For example, we will talk about that later. We expect migration of judges. So you want to get good judges to the UPC, and without filing cases, this will not work. So I believe everybody who's really, for whom infringement or patent litigation actions is really essential, I would see, my personal view, it would be a mistake not to train the UPC. Yeah.
Not to train, not to shape the system, because yeah, if you leave it up to the others, they may try to shape it in a completely different way. Yeah. So that's something you see, and frankly, that's probably not what you want to do. So I think we've got a further question.
Yeah, we have a further question about that, right? I will start that. That's Christian.
That's A. Okay.
So yeah, the question about the training of the UPC. I will start it. And I will read it for you. The UPC will need real-world training to make it a fully functional and attractive venue for patent litigation. Do you intend to participate in that training process, as we just explained, which is possible, e.g. by not opting out or even actively using the UPC? And we have a lot of answers for you here. No, let others do the job and take the risk. First answer, yes, but only passively, but by not opting out. Yes, actively, by only a limited set of less important, I cannot read, less important cases and patents. Yeah, that might be an option to
yeah, sure.
Use the not so important, but that might change rapidly. If your experiences are good, you may change this opinion. And the last answer would be yes, actively and to the full extent in order to shape the system as far as possible. So that's the more offensive way, yeah, to really go into that, to be the first mover.
Yeah, to be a first early adopter, or whatever you want to call it. Exactly. So yeah, one thing I'd like to mention here is, yeah, okay, and we see, well, as responses come in, we see, yeah, it's the third option, actively, but only for less important cases. Yeah, that would be, I think that's the first guess. But at the end of the day, is it really, do you really want to just limit yourself to the less important cases? What does that mean? At the end of the day, it's you're not really training it, just a bit.
I believe it will be that there will be no constant strategy. We have to rethink everything every day.
You have to jump
not every day, but perhaps every half year or something like that. Making first experience with the UPC, thinking about it, and frankly spoken, as I mentioned at the beginning, we have no crystal ball here. We don't know what happens. We have to follow the situation. We have to follow the situation and have to reconsider from time to time the strategies. But here we have quite clear, and I will terminate the poll and give you the results. Yeah, and I am happy, I would say, with the results. Of course, there are some let others do the job and take the risk, especially if you are a company for which patent litigation is not so essential. That's absolutely a reasonable option. But here the main we have about 80% of our participants, and even more than 80%, which are stating the intent to make use and train the UPC. That's for me.
Which is sensible, in my view. It's sensible to do it. You've got to do it wisely, but keep in mind, you're going to end up with it unless you go exclusively for the national route.
Yeah, that's
at some possibly not so far point in time. So this is you better shape it.
Yeah. We are really at the beginning of a very interesting story, we have to say. So for us, it's also a thrill to be part of that. As I said,
having waited for so.
We both work in that field for more than 20 years, and that's really an interesting change. It's really interesting, and the implications are interesting. You have to have fresh thoughts about it, and also others have other thoughts, and at the end, I believe there will be good options to follow. So okay, let's see this poll, and I will go to the next slide. And the next issue, and we touched that already in our earlier presentation here, is that our feeling is that Germany is already a key venue. For SEPs, it's a key venue worldwide. It's more or less clear. So we have here a lot of cases, also in cases in which I have been very actively involved, which rules the world with respect to finding licensing agreements worldwide. We just recently had cases in video compression, and that's one of my major topics in my all-day work. But what happens now with the when the UPC is introduced? And as we said, we want to train it, we want to have it working, and how will that change the picture of which venue will be a key venue? Of course, you can say in Europe then you basically have the same starting point, because if a French court or a Dutch court or whichever court will issue a decision, it is enforceable in every member state country, which covers 350 million people, which I believe is a lot. But we, frankly, of course, because we are German.
What a surprise!
We have the view that things might still concentrate on Germany as they did presently so far. We have in Germany, based on the past case counting, which has been done when discussing which venues have to be assigned to which member state. Germany is the only country, only member state, which has more than one local division. And in fact, Germany has four local divisions. So the local divisions are the ones you know for
the usual
competent. It's Düsseldorf, then Mannheim, Munich, and Hamburg. So these will become the local divisions of the UPC. And as you know, only to refresh, we have 3 judges, 2 German, 1 other nationality, and I guess on a request, a technically qualified judge will be added.
When it comes to nullity
case, I believe.
When it comes to nullity.
So but it's a
invalidation.
So and we have, of course, regional divisions for example, for combining some member states, the Nordic and Baltic states, for example. And we have the central division, which whenever is called the central division, we believe it will be used more for rare cases. It's independent nullity actions,
Attacks,
of course, but I've seen independent nullity actions, but not so many. It's not a big share, and the local divisions might refer the nullification,
nullity part
to the central division. At least for Germany, I don't expect that. I believe the German judges, which we think will migrate to the UPC, will be very happy to have full jurisdiction and have support by a technically qualified member. Yeah, they want to have it in one hand. Yeah, and that's the reason why we believe the introduction of the UPC will not weaken the German venue, but will strengthen it. Also, having in mind the situation with the model cases we explained earlier, where you can use the German court for a infringement action against a Portuguese company. So that was not possible before, and there might be reasons to do that. Yeah, and as we mentioned several times, we believe that the UPC is very likely to mirror the national court practice. On one hand, we expect the judges to migrate, same people, same mindset. So then the rules of procedure have been constructed in a way that every country-specific practice would be enabled by these rules of procedure.
So it allows for application of those, or at least having it seep into the UPC. So as we said, the mindset. So they've decided in a certain way, they've looked at in a certain way at things, at issues. So that is, and the rules of procedure are flexible enough in that, give enough flexibility for the local divisions.
And that was, by the way, I remember because I was involved in the discussion about when this all has been constructed. Yeah. And one important aspect about the rules of procedures was that the compromise is to include everything. Yeah. And not to the alternative would be to select one established rule of procedure successful in a certain country, but the compromise is basically
that's how the EU works.
Everybody. Yeah, it allows everything. So and accordingly, the judges are free to shape the court practice. We believe they will do as they did in the national courts. Also, we believe that they will do as they did in other countries. So in Germany, German judges, German practice. In France, French judges, French practice. So yeah, that's what. Another part of our speculation, of course, but we think that that's the most realistic scenario.
Yeah.
One important issue, of course, we should mention, which really substantially altered, is the bifurcation regime.
The German
bifurcation regime, very popular or unpopular, how you want to call it. I believe usually the effect of it has been exaggerated because the infringement courts have seriously considered invalidity concerns, and the statistics confirm that, as we have about 30% of the cases stayed, 30% of the cases dismissed, and 30% of the cases won. Yeah, I believe that's a fair share. Yeah. So and there was not, of course, there are cases when the how could I say, the first assessment of the infringement cause was overcome by the Federal Patent Court, and perhaps then again overcome by the Federal Supreme Court, the Bundesgerichtshof, but it's not the usual case. So what we want to say, things will change, but will, I believe, not substantially change from what you feel about when you are in a proceeding.
The look and feel of it is going to be fairly similar to what we have right now.
Yeah. And that's the reason why we believe, in fact, as we said, that the German venue will be strengthened. And again, here we have questions for you. And I will start, Paul. And
so I'll do this. Okay, so a simple question. So Germany is currently, as we know, the key litigation venue, patent litigation venue in Europe. And just as a gut feeling on your side, do you think that Germany will keep this role within the UPC, Or do you think, yeah, no, others will be similarly or will gain significantly on impact? Of course, there is a motivation for those courts to attract cases to do that. But yeah, just a question to you. What's your impression? What's going to happen? So that's very interesting. And then the replies come in. So yeah, it's a fairly clear, clear picture in terms of, yeah, it's the impression is that this is Germany is going to keep that sort of leading role when it comes to the patent litigation. So how many do we have?
Yeah, that's a typical number.
Yeah, okay.
We can show you what the outcome is now. So, and here you go.
Yeah, as you see, so a vast majority of the replies is yeah to whatever.
I cannot see that.
Yeah, so it's about so let's say roughly 60% think, or more than 60% are of the opinion it's going to be the same as before, but it has to, interestingly, a lot of the 36% think yeah they have to transfer or keep doing it the way they did before. So that's interesting as well. So apparently, well, there's a reason why German litigation is popular. Let's put it that way. So
yeah, on the other hand, there's competition by other
there's competition,
courts.
yeah, and
it will be interesting
also
for the German courts to enter into that competition more actively as perhaps presently.
For now,
and, we will again see what's going to happen. What's going to happen? Yeah.
Okay.
Yeah. So I made a mistake. So okay. So then we will go back and continue our presentation. And yeah, and we will continue that topic about how the German venue is structured and what are the reasons for success. Yeah, and a main point is, I believe, and that's a little bit more discussed in the last years or months, is that you, as a patent owner, can be happy that injunctions are common practice in Germany. So it's not an exception, and it happens. There's really things gain traction. Your patents are worth something. Your patents enable you to stop others to do the same what you invented.
Yeah.
And as I mentioned in the last section, injunctions are granted in about 30% of all patent infringement cases in Germany. It's an automatic consequence. If you have an infringement and you have no doubts about validity and stay the case accordingly, then you get the injunction. It's your decision to enforce it, and it's not easy always to enforce because you have to place a bond, you have to put your money in escrow or anything else to be prepared for if the case is overcome. So the discussion is a little bit flawed because it's always said you get the injunction and it's easy to enforce. You get the injunction, yes. It's easy to enforce, no. So it's you have to do something, and you have to.
There's a massive commercial risk behind it.
Absolutely, you have to have.
You have to be very confident.
Yeah. We in the SEP situation, we typically have a bunch of patents which we can assert. So the certainty is much more. It's better. So and we got injunctions based on SEPs regularly over the last 15 years, and we enforced them partially where it was necessary.
Yeah.
So so that's important to understand that you do not get the injunction. You get 30% of the injunctions, and but enforcement is not for free. But when you enforce, you can also ask for punitive fines. You can seize bank accounts of the defendants. We did all these ugly things already, and they. And they are very effective, I can say.
That's the motivation.
It has to come to the point. Yeah, so that's what I mean when things gain traction. You get to the point where somebody has to follow. Yeah. Yeah, and yeah, why? And the next question is, and that's why we thought about so much about the mindset of the judges, is why is that possible? Why is it possible in Germany and not in many other countries I don't know of? The basic reason is that the courts have confidence in their decision. And why do they have confidence in their decisions? Because they have an absolutely unparalleled abundance of judgments at all levels, nearly for every detail. You find a
Pretty
decision.
much everything, yes.
You find a decision. It's something which is perhaps not so much known outside of Germany, because we write all this in German and nobody reads it. Yeah, and we try to change that. We will try to make translations of all these decisions on an ongoing basis. But that's absolutely key. The judges can be confident that somebody else has decided. And when you have to make an infringing a positive judgment, granting an injunction, you have not to answer one question. You have to answer typically dozens of questions. Yeah. And for all these questions, you have at least similar decisions, even by the Supreme Court, which is absolutely regularly handling patent cases. So that's the basis for this possibility. Which
yeah, that's the reason for doing it. And again, it brings us back to that's what the German courts did, and that's something going back to the training of the UPC. You want to establish there as well. So again, it's all about using the system and making it work by actually giving feeding cases into it.
Yeah, absolutely. And thereby also motivating judges changing from national courts to the UPC courts. And these we have to. Sometimes I had a case. Oh, it's also some time ago, but I cited a decision from 1912, from the what was it, 21? I don't know exactly.
Whatever. Long ago.
Nearly 100 years ago. I don't know exactly how this tradition has been established. I believe Germany at that time was in the movement to become, when they first were called China of Europe. Yeah. So the innovations came from Britain in the late 19th century, early
made in Germany.
And then Germany first copied and then started to invent itself by themselves. And that was the reason we mentioned that made in Germany has been introduced to label.
It's a British moniker for German.
For copying
their inventions.
But at some point in time, that changed, and Germany became very pro-innovative. And this is a very long tradition. And the result is, and that's for you as users of the system, extremely important. This is really an excellent predictability. So based on that abundance of judgments and our knowledge of pleading before the court, we can really give you a good feeling about how the outcome will be. Yeah. There's no guarantee. There's never a guarantee before court. But yeah, so you have really excellent predictability. Yeah, that's, as I said, one reason why Germany has become a key venue, and one consequence of that is, from our perspective, what we see in our infringement cases are typically applications which have been written 15 years, 10 years ago. And at that time, there was a large movement to adopt, especially internationally, not for German applicants, but for international applicants, to adopt strategies on preparing applications in a way heavily influenced by US jurisdiction. And we believe that we believe it might be sensible to change that. And to tune. And that's here the next icon here, to tune your applications to
the German enforcement practice. So which is massively different from US litigation practice, but also from US filing practice. So my daily work is pretty much oppositions, and a lot of them EPO oppositions, a lot of them based on US style applications. And the biggest problem we have, before the EPO, remember, you have to go through the EPO first, at least if you're interested in the UPC unitary patent route. this is not what the EPO likes, and at the end of the day, not what the German courts like.
Yeah.
So the key, basically generating feature clouds. That's how I labeled that, without telling a real story. And when you end up, say, be it in EPO opposition, which is the first bottleneck you have to go through in many cases, or ending up in German litigation, what they are missing is that you're telling a compelling or a story, a straight story. And my point on that is you may always have side branches, and you may have to change your story along the way as you move through opposition, as you move through nullity, prior art comes in, and you have to change your story, but you've got, nevertheless, the plot is laid out in your patent application. You better lay out the plot in your patent application. Tell a story, because that's what they are looking for. With EPO, but especially with German courts, they look for the story. What's the interesting thing about it? What do you think you invented? What's the benefit of it? So really be bold and say these are the advantages in our point of view, to write it into the patent application, because the judges, especially when it comes to to German infringement procedure, they want to read the patent, and they want to understand, and they need the patent to tell them what the story is, what the benefits of all that is. So rather than having 100 embodiments, just give them a couple of advantages, write it in a way, write your patent application in a way that is a clear and consistent story. As I said, everyone's forgiving if you have to change the story along the way, but at the beginning, you have to tell it. You have to say, okay, this is what I invented. This is what I thought my invention was. As said, that may change, and everyone's aware of that this may change. But nevertheless, as long as there is a certain line within that, that's what they want to see. And I said again, they are very much in Germany. They apply the function-oriented claim construction. So you basically, it's about what's the functionality of it, rather than just throwing features at them without telling what yeah. That's it. And they say, yeah, okay, there's a bunch of features, but what do they do? Yeah. What's the point? So
that everybody at German courts knows that the advantages have been written against the prior art, which has been discussed in the patent application. And if there's other closer prior art, then you can modify the advantages. So that's not a problem. So as it's written here, the function-oriented claim construction also encompasses a broad view is made against a broad understanding or a deep understanding of the invention. And based on that understanding, you can allow modifications, yeah, which are in the scope, they are not looking totally formally on the language. They think about what is meant and what is the plaintiff is claiming.
What was the technical story behind it?
Is the claim of the plaintiff still in line with that what has been really described in the patent specification? Long story short, message. If you do that, I believe you get much closer to the 30% and even above of the 30% to get an injunction claim in Germany, which may be important for you.
Yeah.
And therefore, it would be our recommendation to consider that. And even against the background of the UPC, that effect might be strengthened.
Yeah, certainly.
Yeah, and now we come somehow to the conclusion, which is
okay. Okay, so action items. Let's move up. So what do you have to do now? I'm sure. Well, at least we hope to have given you a bit of food for thought. What might be the right thing for you? What you might want to consider? Perhaps you knew already everything. Okay, good. But at least as we thought about it and prepared that presentation, it's always something to, yeah, okay, good. I should think of that. So we try to, as you know, you will hopefully recognize the icons that we've spread across the slides. So there is no, not unsurprisingly, there is no one-size-fits-all strategy. It's all driven by your business. At the end of the day, what are your business goals? What do you need? What does your competition look like? What are your financial means that you have? So that's all factoring in. So when you're small, and we try to categorize that, unsurprisingly, essentially based on the size of the portfolio, right, and of your activeness in litigation, which typically goes along with that size. Number. So yeah, a small and mid-sized portfolio, you rarely enter, or it's in many cases a more passive approach to you're more defensive. What you want to look at, and what you really have to think of is really, and these are the two icons down here. Okay, so think of the right path where you want to go, and nevertheless tune your patents as well. Again, for a passive portfolio, you have to have good claims. You have to have stuff that is really there. It's also litigation driven, because the only thing that, even if you use your portfolio passively as a defense, the only threat you can create is that you've got a good patent with claims, valid claims that really hit someone who wants to hit you. That's the only threat you can generate. So you look at the other ones, what do they do? Can I cover them? And that's a good defensive patent portfolio. That's what you have to strive. Mid-size and large portfolios, yeah, in many cases you've got opposition proceedings going on a regular basis. That's what we see, not in all fields, but in quite a number of fields where opposition is going on, where this is also already tested early on the EPO level already. But here as well, you're more prone to enter litigation. So you've got your action items. As said, again, steer your way. What's the right filing strategy? Use the UPC. To what extent do I have to use it? And again, tune your patents to what you expect to see in litigation. Just be aware of that. And
perhaps one word about tune the application and the patent. The reason why small and mid-sized portfolio companies are typically not so often involved in patent litigation, also about cost. But what my experience, or our experience, our firm, is that does not mean the patent is not worth anything, because the companies discuss the patent. There are not so many patents to be discussed, and they are still there. Provide protection, but you don't have to go to court, because you can make yourself understandable to the other party more easily. That also applies to a large extent also for mid-size and large portfolios. So the reason is not the situation that you do not go for infringement is not that you don't need the patent, but you don't want to assert it in before court. You want to discuss it with your competitor. That's you want to have a reasonable, another way of enforcing it. If you create a large enough threat for the other side, they will talk to you. And nobody is interested, unfortunately, in spending money for attorneys if it's not necessary. But that's another topic. That's another topic. So and at the end of the day, unsurprisingly, for the large portfolios, high value patents, not necessarily, it mustn't be that, it does not need to be that many, but there needs to be a lot of value involved, and that's what you see. So you've got seasoned litigation practice there, and unfortunately that's where you have to think of all the points that we raised, and rather sooner than later, because it's likely, as we know, it's going to hit us. Finally. And this is typical portfolios, as we mentioned, and perhaps self-explanatory. Pharma and standard essential patents are the typical.
But also others.
Also
yeah,
others.
But that's the usual suspects.
Broadly used technologies, also application-specific patents for very popular products and this kind of stuff. And coming to the point, what is I take that for a second. What is the most pressing item? I believe the most pressing item is think about simultaneous protection and double protection. That is something you really should consider soon, in our view. The next issue is it's perhaps not that pressing, but it comes to you. If you continue finding how do you say clouds or features?
Feature clouds.
That will come back to you at a certain point in time. The earlier you start to think about if that's should be modified or reconsidered at least, the better. For the filing strategies here, there is basically the deadlines are clear. They are, I would not say relaxing, but it's not so. It does not provide you non-sleeping moments.
Yeah.
So and the same is basically true for opt-out situations. I believe, which is also somehow pressing, is the question of training, because that's something I believe that's a decision which is a part of a larger view on IP in your company. So what I wanted to say, you have more people to involve in thinking about it.
Yeah.
It's not something, but really, it is really a key issue and a complex issue, which you, where perhaps the time is needed to make that decision, depend on how many people are involved to make that decision. That's here the one important issue, I would say. So nothing is unimportant, so otherwise we would have mentioned it. Pressing items, simultaneous protection and tuning applications, and the other things, the deadlines are clear, and this is a heavy stuff here. Question. It's we are good in time.
We're almost done.
So we can start discussion, and we'll now try to find. I go into our questions and answers. We do not have so many questions and answers. We have one question. What are the translation requirements in the event of a dispute? Seem to suggest that a full translation of the patent into an official language of a venue of alleged infringement may be needed before a claim for damages against an alleged unknowing infringement can be made. Does it mean that we need to proactively submit full translations of venues of frankly spoken, I'm not totally sure. My feeling is that before you start a case, the translation might be in any event useful to protect yourself. Translations, is my feeling, became much easier with machine translations. We do a lot of machine translations and they get better and better. Perhaps not in every language, but especially in the patent world, we have a very good data mining due to the lot of translations. So yes, I would recommend to do that before you file a case, but that has to be coordinated in detail and as a matter of caution in any event. So I hope I answered that question. Do we have other questions? No, we have no other questions, but we thought that it might be a good idea to enter into a personal discussion. So far you have not had the opportunity
to speak
to us. And if I understand the technical part of the situation correct, you have to raise your hand in the Zoom application, and when you raise your hand, we will introduce you into a personal meeting room, and we can see each other and listen to you and speak to you. If you are interested, you're highly welcome. Otherwise, for the ones who leave us now, we will now enter into the discussion. I don't see, I believe I should stop the presentation, right?
Yeah.
Yes, okay, that's fine. Do we have some people joining the discussion? So it seems to be that we answered all questions.
Huh.
So yeah, good. And yeah, when you leave our webinar, you will get some questions about how you liked it. That would be great if you answer it. And there's one other. We are just
okay,
hearing
here
that there was another question. Which other EU countries of simultaneous protection like Germany? As I said, I believe none. But I'm not totally sure.
Not explicitly.
The situation frankly spoken, I'm not sure. That is why I said I believe. I believe nobody else has. We have been involved in exactly that question when we thought it should be. Or it would be an act of negligence to wipe away the German system by introducing the UPC without competition, and that has been discussed in the corresponding forums, and the result was that the simultaneous protection exactly for that purpose. I believe such discussion has not happened in other countries, and accordingly the rules have not been made, but they might. Of course, they might change. From my perspective, it's presently only Germany. So, okay, that was the last question. So you can see we have still 42 participants. If any other questions will come up. No?
And there's no stupid questions.
We can confirm that we stopped recording. So if you answer questions in person, that is outside of the recording. That I did not mention that. But we have a chat here. Thank you for very much for a very interesting talk. Thank you.
Thank you. Thanks for listening.
Exactly. For participating in our polls. Yeah. Okay. So there are no further questions. We are perfectly in timing. Thank you.
Thanks, everyone.
Have a great day.
Have a great day.
Bye-bye.
And see you soon. Thank you.
See you soon.
Bye.
Bye.